I'm Mary Ferreter, the president of AFCC. Today, our topic is the to recommend or not to recommend, which I think is going to be one of the probably most debatable issues that we have seen so far, and certainly I think will be the liveliest debate we have seen so far, which says a lot considering the evening session that we had the other day. This program itself stems from the last Symposium for Child Custody Evaluators that we had in Nashville, where the discussion began whether recommendations should be allowed in child custody evaluations or are helpful, and are they actually going to the ultimate issue that the trier of facts is the one that's supposed to be making the determination on. And after that symposium, behind me are Tim Tippins and Jeff Wittman, who wrote the article in the AFCC Family Court Review. The initial article went in the court review for April of 2005, and Lorraine did a commentary on that article, and then Nick Bela did the response article in the October 2005 Family Court Review. So if you're hearing things today, I'm sure it's going to be fast and furious. If you want to go back and look at what they have written, their scholarly articles are just wonderful, and I would urge you to go back and read those articles. They are very enlightening. Jeff is a psychologist and child consultant and divorce mediator, and also the author of Custody Chaos, Personal Peace. And behind me is Tim Tippins, who is a lawyer in private practice in New York. He's the former president of the New York chapter of the American Academy of Matrimonial Lawyers and the former chair of the New York State Bar Association Task Force on Family Law. He's also on faculty at the Albany Law School. And then on the other side of the issue, we have Nick Bela, who is faculty of law at Queen's University in Kingston, Ontario, and was a visiting professor at Duke University Law School. And then to my furthest left is Lorraine Martin, who is the clinical coordinator in the Office of the Children's Lawyer in Toronto, Ontario. I should just shut up and get off of here. She was also the co-chair of the AFCC Task Force on Model Standards for Child Custody Evaluations. And last but not least, we have Arnie Scheinvold, who is now our moderator extraordinaire, on top of being a psychologist, custody evaluator, and mediator, and a member of the AFCC Task Force. Thank you.
Okay. Thank you, Mary. The issue we're looking at this morning has to do with the whole area of whether or not custody evaluators should be including recommendations in their evaluations, especially at the conclusion of their evaluations. Although Mary stated that this argument was brought before AFCC in the 2004 Nashville Symposium, in fact, this has been a question that's been out there much longer. There have been articles from the early 80s raised with respect to whether or not recommendations are the appropriate domain of mental health professionals, of custody evaluators, per se.
Okay, good morning, everybody. Let me just dispel a few myths that tend to be floating around. Tim and I, after writing the article, have been characterized as trying to trash the mental health disciplines, as impractical, as out to crucify mental health experts, essentially as the epitome of evil. And each one of those things is true about Tim, but not about me. So this debate is framed as to recommend or not to recommend. Is that the question? Tim and I have concluded that, in fact, that's not the question, that the much more foundational issue underlies that title, which has to do with whether or not the mental health disciplines have an adequate empirical basis for making custody recommendations. What we're not saying, we are not saying that a psychological report should be excluded from family and Supreme Courts. We say multiple times in our original piece that they're critically important to children and families. We are not saying that litigation is a good thing for children and families. Our model is exclusively focused on situations where we have crossed the threshold, where a family has crossed the threshold into a court setting. We are not and have not addressed all the creative options prior to that crossing of the threshold. But when families do have the unfortunate circumstances of having to litigate about custody, they have entered a context in which their human liberties, the child's human liberties for access to his or her parents, the parents' liberties for access to their children can be truncated, and the trajectory of their lives can be changed forever. This is not therapy. The forensic can't be fired in the same way that can happen if we go for advisory information in therapy, so it's a significantly different context. I would propose that any parent that goes into a custody evaluation should have the following question rattling around in their brain. Doctor, given that you will be rendering an opinion that could change or that could cause me to lose significant access to my child, would you kindly present the evidence that your discipline is able to make such a designation in a reliable and valid fashion? There should be silence at that point. Everyone functioning in the adversarial system is functioning in the absence of a source of perfect knowledge. But given that human rights and liberties are at stake, we have an orderly, specially constructed system for protecting those liberties. One writer spoke about the show me principle, which I think is a simple and elegant way of understanding what we're talking about. In a court context where recommendations can change the course of someone's lives, the question should be whether or not the expert can show the court that they are in fact able to reliably and validly offer the inferences that they are offering in that court of law. Our essential position, which is no surprise to most people here, is that we have as a discipline, psychology, psychiatry, and social work, we have no empirical guidance for how to weight relative differences between parents on the various traits that we assess them on, and that we have little to guide us with respect to the relative needs of different children. We have some guidance, but little. There is absolutely no evidence available that establishes the capacity of mental health professionals to reliably and validly choose the best custody plan from an array of possibilities. So our model essentially suggests the following: that forensic psychological assessments should continue to be regularly ordered for children and families to answer salient psychological questions that are relevant in a particular case. However, given the lack of valid and reliable knowledge base for selecting custody plans from an array of possibilities, mental health professionals should stop making such recommendations and should constrict their conclusion sections to essentially an analysis of the relative psychological risks and advantages associated with different custodial plans. All inferences about risks and advantages should be supported with explicit references to the empirical research base. Essentially, we should begin to take more trips to the library than we have been to date. And more than anything, what our model is emphasizing is that it is time for the pretense to end. We have to stop the pretense and that our field is able to make these custodial designations in a reliable and valid manner. It is about beginning to be appropriately humble and open about the limits of our discipline. It's essentially about telling the truth and about ending the practice of rendering forensic opinions without a trip to the research library.
I think in their introduction, in their piece, Jeff and Tim make some very important points about the limitations of evaluations and of knowledge in this area. And it's certainly an important argument for evaluators, judges, and lawyers to listen to. But when I was reading their article and listening to them, and then went and spoke to judges and lawyers, it became very clear that most family law lawyers and most family law judges do not agree with this position. And of course, it's not an original position. It's been one that's been argued for the last 20 years or so. There certainly are some law professors and others who write articles and say, and in their argument, in their article, they make the point that the literature does not support the admission of this kind of evidence based on what in the United States is called the Daubert standard. In Canada, we call it the Mohan standard. And why are family law lawyers and judges ignoring this? And I've recently done some research in Ontario and again found that in the context of child welfare proceedings that over 90% of judges want to have recommendations and over 80% of lawyers want recommendations in these assessments or evaluations as well. And I think that the focus has to be on recognizing there are actually a number of different questions that have to be asked. One is, when should an assessment be ordered? And it's not always appropriate to have an assessment at all, and if an evaluation. And if an evaluation is being ordered, should there be recommendations? And I think the judge and lawyers who are asking for that evaluation have the right and responsibility of indicating whether or not they want recommendations. I would say if they don't say anything, then the presumption should be there will be recommendations. But there are cases where recommendations may not be appropriate. Then there's a question of whether or not to admit the assessment or evaluation once it's actually been done, and what weight to give it, and those are different questions from whether or not to order it. And finally, there's the question of what kind of other evidence might be admissible later on. It is certainly true that when making a recommendation that involves the best interest of the child, this is not a purely scientific inquiry. This would not, in my view, meet the test of Daubert and Mohan. But nevertheless, evaluators, whether social workers or psychologists, if appropriately trained and experienced and knowledgeable about the literature, should be in a position to make those kind of recommendations. They're clearly very important for the court. They're clearly very important for the parties. Judges generally want them, and they want them with good reason. They recognize that they, as a judge, are not making a purely either legal or scientific inquiry. It is one that has elements of law, of social science, of psychology, and your recommendations, informed by science, but not totally scientific, may be very important to help them. This is very different from the role that is ordinarily carried out by expert witnesses in the litigation process. And so the model that is taken in the article, they argue, look at the Daubert case. Daubert was a tort case. In Canada, we have the Mohan standard. That was a criminal law case. And they were a case involving party-retained experts. That's very, very different from when the judge looks to you and says, I want you to help me, and the way you can do that is the following, sets out certain parameters, and please advise me about what you think is the best interest of the child. If the judge asks that, I think it's appropriate to do that, and many judges want to do that. They know that you are there in part on behalf of the child. And what makes this different from ordinary civil litigation, where these kind of rules apply to ordinary criminal litigation, is the judge recognizes that he or she has a responsibility to the child that is different from the responsibility solely to the parties, and that you may have a very important role in bringing forward your opinions about that. And they also recognize that assessments, evaluations that have recommendations are much more likely to result in the settlement of a case, and that's an important part of their thinking when they're making the order. But I'll let Lorraine finish my thought on that point.
Yeah, you have about a minute left.
Pardon me?
You have about a minute left.
I have a minute. I'm not a lawyer. I'm not a forensic psychologist. And I think I'm a voice for the public sector evaluations. And I think Tim and Jeff's argument have an inherent assumption that all of these go to court and need to be critiqued in that or understood in that light, and they don't. And I'll be making some points, hopefully, if I'm ever asked a question by the moderator concerning the settlement function and the usefulness to families, first, and secondly to the courts. I think that the evaluator is better informed and in a better position than the judge to understand the family and what kind of plan might work for the family. I don't think we've been at this conference told many times to ask open-ended questions to elicit the best information. Well, a judge certainly isn't in a position to ask open-ended questions, and we are.
Okay, thank you for keeping it close. So we have these two positions, whereby one, and in fact in your article, Jeff and Tim called for a moratorium on making recommendations, level 4 conclusions. And we have Nick and Lorraine who are saying there is some basis for making recommendations and should remain. Nick, the title of your article was "They Asked the Wrong Question." In your opening statement, you kind of mentioned several questions. Could you either tell us what the right question is, or maybe expound a little bit more on the right questions with respect to that? Is there any more you can say with respect to that?
Well, I think this is a really interesting debate. It has both a legal dimension to it and a social science or a mental health dimension to it. In legal terms, I think that the question that they asked in American language is, can an evaluator give a recommendation that would meet the Daubert standard? That's a legal question. And I would argue that, and that's really, to me, as a lawyer, reading their article, that was their central message. There is, as Tim said, another side to that. And I would argue that's simply the wrong question, and that's not the question that judges typically ask themselves. They really say, would it be helpful for me as a judge to have a court-appointed expert, not a party-retained expert, go and do an evaluation and come back with a recommendation? Yes, it would help the court. As Lorraine mentioned, one very, very important function is it may help these people settle the case in a way that they would not otherwise settle. Many people can settle before they have an evaluation. They don't need a full evaluation. But if you're coming down and it looks like the case is going to trial, an evaluation often post attempts to settle the case through mediation or whatever may well help the parties settle the case. And that's a very important social function. It's one that will help children. Children are almost always going to be better off if the parties have settled after a good evaluation based on recommendation. If there's no recommendation, I would be worried that parties are much less likely to settle the case. So that's a very important function. And the questions that judges actually ask themselves, though, I think in the family courts, I mean, including the superior courts, are, should I order this evaluation? If so, on what terms? When it comes back, should I admit it? What weight should I give it? Should I consider any other evidence? So asking very different kinds of questions, and I think appropriately asking different kinds of questions. I would argue that, and certainly in Canada, I've read some cases where judges are persuaded. Some judges are seduced by this argument. It's a very persuasive argument. These are very persuasive writers and presenters. And they say, well, in this case, I don't think I need recommendations. And they read the Tippins-Wittman article and say, look, Tippins-Wittman say, don't order recommendations, so I'm not going to have recommendations. Or maybe I don't even need an assessment. This isn't even admissible evidence. I won't have an evaluation done. And I think that they often, when I read those decisions, they may be right on the facts. So they're right. In this case, it would not be appropriate to have recommendations, or maybe not even appropriate or necessary to have an evaluation at all. But they then just pull this article off the shelf or pull the case off the shelf and say, that's why I'm not admitting it. And I think there are good factual reasons on those particular cases not to have the evaluation, not to have recommendations, but they shouldn't take the whole argument because there are many cases in which the recommendations are appropriate.
Okay. Did you want to add anything to that, Lorraine, or are you okay?
I want to hear.
Okay, I was fearful because you kind of said I wasn't going to ask you a question. I got worried. Which one of you gentlemen would like to respond to that?
First of all, I'd like to indicate this is a banner morning for me because it's the first time this weekend I've been introduced without reference to the evil bastard moniker that Martindale and Flens and Gould have hung around my neck, and, which I'm convinced will be on my tombstone.
The morning's not over.
Evidence. I'm sorry, I missed it.
I said the morning's not over.
The morning is young, Arnie assures me. Our model is based upon evidentiary integrity. The rules of evidence are complex, and we'll talk in a moment about what we see to be the right question. I think this debate is perfectly modeled or framed in saying, is that the question? And as Jeff has already indicated, it's a question. It's a sub-question that flows out of the paradigm that we've put forth, but it is not the central question. It's very easy when dealing with the rules of evidence to confuse the issue, and particularly in the labyrinth of rules pertaining to expert testimony. I can exemplify that by telling you about a case from New York, which I do for two reasons. One, because it does illustrate the type of confusion that can enter in, and secondly, because Lorraine, who I love, asked me to do this because she heard it in Nashville. There's a case from the late 60s in New York State called People versus Centolella. It was not a custody case. It was a criminal case. It involved a robbery. The owner of the store up near Syracuse in Onondaga County, a rural area, comes to the morning. And Arnie's assured me he's not going to count this against my time to respond to the
I started
question.
your time a minute late. Go.
Comes to his store, sees that it was robbed. He calls the cops. The cop comes with the trusty bloodhound, who's even named in the opinion. It's one of the most entertaining opinions to read. Colonel of Redstone is the hound. The hound sniffs around, picks up the scent, takes off like a shot out of hell across the pastures. The cop's trying to keep up with him. Finally, the cop comes over the hill. There's the dog at the base of the tree, looking up at the top of the tree, going woof, woof, woof. At the top of the tree, Centolella, the defendant. You fast forward to trial. The deputy's on the stand. The prosecutor asks him, did you come over the hill? Yes. Where was the dog? At the base of a tree. Where was the defendant? At the top of the tree. What was the dog doing? The dog was saying woof, woof, woof. At which point the defense counsel objected. Hearsay. The judge calls him to the bench where he can speak freely. He says, counsel, what the F are you talking about? He said, Your Honor, we understand doggy talk. When that dog says woof, 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 he's saying that's the man. It's an out-of-court statement. They want to bring that son of a bitch in, I'll cross-examine him. But until they do, it's an out-of-court statement, it's hearsay, it should not come in. The judge says, sit down. There is a legitimate evidentiary issue there, counsel. It's not the one that you state. We'll get to that after your client is convicted. Sure enough, the client is convicted, and the judge actually renders the opinion that you can go and read in the books. And the opinion says there was an evidentiary issue to be sure, but counsel got confused. Counsel objected to on the ground of hearsay. He said, however, the judge, I too understand doggy talk. And I know when that dog said woof, 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 he was not saying that's the man. He was saying, in my opinion. That's the man. Therefore, it is a question of whether he is qualified as an expert. And an opinion that presaged Daubert, the judge actually goes through the dog's error rate. How many times has he successfully tracked the human trail versus how many times he has not found the dog to be qualified to render the opinion on to the next case. All right. In the terms of this discussion, the question is one fundamental question. Back in 1992, during Bill Clinton's first campaign, for all of his brilliance, he had a tendency to get distracted out on the campaign trail of what he was talking about. And his political guru, and this is legend at this point, Carville, put up a sign in every campaign headquarters. It's the economy, stupid. All right? Well, here, and I'll leave off the pejorative, it's the validity. It's a fundamental question of whether or not we are going to insist upon evidentiary reliability, which for the benefit of mental health professionals in the room, when the law speaks of reliability, under Daubert, it is equating that to what you as mental health professionals would refer to as validity. Are we going to have a standard of validity or are we not? There is a reason why the APA ethical principles and code of conduct refer to using the science of your profession. There is a reason why the Division 41 specialty guidelines say that you are to keep current on the research and to use that in the work. There is a reason why the custody guidelines of the APA refer to relying upon the scientific literature. And they are the same reasons that the law insists upon reliability, so that litigants in all species of cases are not subjected to determinations and truncation of their liberties on the basis of unreliable evidence, whether it be fact or opinion evidence. That is what is at stake in this debate and in every courtroom. The Supreme Court of the United States in Troxell versus Granville said that the right of a parent to parent the child without state intrusion and truncation of that liberty is a fundamental right under the Constitution. I see the importance of the work that you do as only one nano-notch below a criminal case, because the fundamental right of parenting is at stake. If we're going to insist upon evidentiary reliability for a tort claim involving a broken arm in an intersection, I happen to think that the families that we serve are entitled to every bit as much evidentiary reliability and validity as the tort litigant. If we're going to say that GM, IBM, and Microsoft are entitled to having a standard of evidentiary safeguard applied, I say so too are the families and the children who we are serving in this realm. Validity is the fundamental and most important question here. Our position on this is not the most conservative position out there. O'Donoghue and Bradley proposed a moratorium, not on recommendations, but upon any participation by the mental health profession in custody cases until greater scientific coherence is brought to bear. In the responsive piece by Kelly and Johnston, in response to our piece, they proposed that custody evaluations should be confined more to dependency cases or to cases where you have definable research-based issues such as domestic violence, parental conflict, and so forth, where there is something to be said from your research base. Because otherwise we're talking about two good enough parents and we're splitting hairs, and you can't do that on the basis of the empirical research base of the profession. The behavioral science literature doesn't answer those questions because they intrinsically involve social and moral judgments. If you look at the most recent article out there that came after ours, 2005, Emery, O'Donoghue, and Randy Otto, they indicate in there, why is it that all of a sudden the whole emphasis in a custody case is on the psychological impact? Why aren't we calling in dietitians? Why aren't we calling in theologians? In New York, as in several other states, moral character is an issue. Accordingly, evidentiary reliability is the only thing that preserves the line between valid and invalid evidence. That's what's at issue in this debate.
Tim, before you sit down, I have one quick follow-up question and then let Nick respond to this. You mentioned the Kelly and Johnston article. Would you agree that they do not suggest that recommendations be eliminated from custody evaluations?
No, what they have proposed is that, in effect, is that custody evaluations be limited to those areas where there is research to support what is being done. They don't actually come out and say, therefore, we shouldn't recommend. But I see their position as more conservative than ours. Okay,
thank you. Nick, would you like to respond to this? And in so doing, one of the things that Tim has brought up, and if you don't have a dog story, that's okay. Tim has brought up this issue of the standard of evidence and the standard that needs to go, and certainly your article addresses that. So if you would respond to that.
And I should say, I don't read Kelly and Johnston as being nearly as conservative as was suggested here. I think and I would encourage you to read the article. It's somewhat broader perspective, and I think they take some quite significant differences to what Jeff and Tim have been writing. And of course, it may be that in upstate New York that dogs are considered to be expert witnesses, and if that were going on frequently in the courts in your jurisdiction, you may well have a different view about experts. But even in New York State, the Matrimonial Commission, which heard Mr. Tippins' very eloquent and persuasive language and engaged in an extensive inquiry, did not adopt his view about this issue. Certainly there are some judges there who don't want recommendations, but there are more, I understand, in New York State who do want recommendations than who do not. I think that the way, and he certainly is it's a very powerful argument to make, and if your standard is scientific validity, then opinions about recommendations are not admissible. If that's the question, he has the right answer. But I don't think that's the question that the legislatures want when they put forward rules about that allow for or the courts or whoever is establishing rules about the appointment of evaluators or assessors. They are not asking for scientific reliability. And indeed, this goes back to the fact when they were looking to judges and they're saying, so the judge is making a decision based on the best interest of the child. That is not a scientific question either. It is a mixed social legal question, and inevitably the judge is going to be informed by his or her own values, biases, and perceptions, and therefore it is often valuable for that judge to hear the views of someone who has had the opportunity to meet with the parties, who has studied and worked and has experience in the field of doing assessments, meeting with and interviewing children and parents. And in fact, I don't think it is not the liberty of the parents that is the central issue in a custody and access case. Rather, it is the best interest of the child. And that is why I would argue it is a different rule that should be applied, and it is a different rule that is being applied. And in fact, in the United States, and there's been some discussion about whether or not the Constitution applies to a dispute between two parents. And largely the courts have not accepted that exactly for this kind of reason. They say that a child welfare proceeding where the state is trying to remove a child from the parents does involve constitutional issues. But the constitutional issues in a parent and versus parent dispute are very different and quite a bit attenuated and similar in Canada. So what I would argue that there should be a different standard, and largely the courts and legislatures have accepted that.
Are you going to, well, he still has 2 minutes. Are you going to say what that standard should be?
For admissibility or for constitutional purposes?
Admissibility.
Well, I think that the standard, certainly on coming back to admissibility, I think there are some things that, if you want, in legal terms, I think that the Fry standard, I think there are some things that some evaluators are doing that are not considered generally acceptable within the community, within what the AFCC and other professional bodies are articulating. Certain kinds of tests, for example, that some psychologists are giving, and then using that as a basis of opinion, which would render their evidence inadmissible. But most of the, and so I think that to me, the fundamental point that I take from what Jeff and Tim have written, and it's a very important one, is assessors, evaluators have to be familiar with the literature, and some of the things that some people are doing are inconsistent with the existing literature, inconsistent with accepted practice, and outside a research context shouldn't be done, and if they are being done, should render their opinions inadmissible.
Okay.
I respond briefly?
Of course.
What I would like to know is if the standard of evidentiary reliability does not apply, and even if we frame the issue in terms of the child's right and the child's best interest as opposed to what, at least in the U.S., is regarded as a fundamental constitutional right on the part of the parents, why is that child, whose fate and future is hanging in the balance, not entitled to a determination that rests upon evidence that's demonstrably reliable and valid? Why is that child entitled to any lesser evidentiary protection with respect to the quality of evidence than a court, contract, or commercial litigant may be? And with respect to the Matrimonial Commission in New York, yes, they heard both sides of the issue. Phil Stahl joined Jeff and me in debating those points in front of the commission. But then what they did, if you read the report, is they took an informal poll of judges. 37% responded and said, we like recommendations. 34% responded and said, we don't. And the commission, very much like the jury, that after 9 months of hearing testimony said, well, we don't want to get involved, the commission came out and said, well, we're going to leave it up to individual judges because there's obviously no consensus out there. The point is the Matrimonial Commission's report is not law. The point is that even an administrative body such as the Judicial Administration cannot, by administrative rule, make a determination on the validity and reliability of the evidence. The legislature has never delegated to the Judicial Council the constitutional authority to do that, so it would be an action that would be ultra vires. The reason why there's resistance to Daubert and the direct assessment of evidentiary reliability among judges, which was raised earlier, is because it's harder. It requires more work. It requires more thought. and therefore there's resistance to it. But this trend was kicked off by Daubert 13 years ago. 13 years is a very short amount of time in the life of the law. A trend has emerged toward greater gatekeeping, scrutiny. That's where we're heading. It's going to affect all levels of expert testimony. It's not unique to custody evaluators. Things such as latent partial fingerprint analysis, hair analysis, and the like, all of this is subject to review and reanalysis under the stricter standard. I want to know why children are entitled to any lesser protection than are IBM or Microsoft when they litigate their claims.
Did you want to continue his time?
Yeah.
Sure.
I fail to see how receiving a court order that renders me to every other weekend and a Wednesday night with my children does not represent the loss of an important human liberty. I don't get that. We are the discipline who went for years believing on the basis of the theory of catharsis that if you let people whack each other with foam bats, they're going to end up being less angry. The research has shown no. They'll end up less angry for about 5 minutes and they get more angry. We are the discipline that redirected many lives on the basis of the concept of the schizophrenic mother. Mothers make people psychotic. We are the discipline who limited liberties with children or possibly allowed many children to go unprotected on the basis of invalid anatomically correct dolls. We are the discipline that for years went with the simple moniker, figure out who's the primary psychological parent, place the kids there, and they're going to be fine, at a time when research was emerging to suggest that that may not necessarily be the wisest direction to go. So we need to remember that whether we are from the field of psychology, I would propose social work, and I propose psychiatry, our highest calling, really, in these cases is to make sure that we're not just sitting back in our armchair and allowing our own subjective biases to affect the recommendations that we make. And I think that one of the problems is that the research is suggesting now, and I think it's quite frightening, that if you look at the percentage of practitioners who actually go to the library and read research, it is frighteningly low. It's embarrassingly low. And the concern that we have is that without requiring the trip to the library and without constricting what psychologists and social workers and psychiatrists can say in court, that in and of itself may present a risk for children. Because remember, we don't know how often we get it wrong. We become very self-congratulatory in this field, and we really don't know whether some of the principles that we've been resting our opinions on ultimately will turn out to not necessarily having been good for children.
I think Lorraine would like to speak.
My turn. Blah, 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 blah. I understand a little bit about what they're talking about, but it doesn't fit in the real world for me. In my province, we do 1,600 new custody evaluations a year, and we also assist in working with counsel in settling matters. And if I certainly can't argue the question in your arena. And as Nick says, if I understand it correctly, if you ask the right question, you probably have the right answer. But I cannot believe that we will ever get to a place where talent, art, and informed science won't be part of this work. And I would want to bet my children's and grandchildren's future on a Jonathan Gould or a Bill Austin or a Rachel Birnbaum, somebody who's seasoned in this field and comes to these conferences, than a particular legal or scientific principle. Realistically, I do not think that these families get before judges all the time, and quite frankly, excluding the wonderful judges in this room, I would not want to take those judges to the water and hope that they would make the right decision. I think these families need an opinion from us and a recommendation from us. Those of you who work with a lot of these high conflict families know that they are stuck in the conflict. They can't help it. They're addicted to the conflict. It's like a vortex. It's got them totally engaged, and most of them harm their children because the conflict erupts in the presence of the children. And we know from the research that that's what we need to protect the children from. So we need to make recommendations that they would not necessarily come to, nor would a judge come to structure those exchanges so that those children aren't in harm's way.
I think that the argument was very powerfully put about why is a child different from the liberty of Microsoft or Google or whoever. And I think that the answer is that what a court is doing in these cases is very different from what it's doing in an ordinary criminal or contract or tort case. It's different in a number of ways. In a criminal case, the O.J. Simpson case, well, did he commit that crime or not? It is a retrospective inquiry about a factual matter. And one wants to know, is the evidence that someone's bringing forward clearly scientifically reliable to establish that fact or not? In a custody and access dispute, it is inherently a prospective inquiry. It's not looking back at some fixed event that one in theory could know what happened, but it's looking forward to the future. It is inherently an uncertain, prospective, predictive undertaking. Very, very different. Furthermore, in most places except for Texas, it's being done tried by a judge alone, not with a jury. So there's a very different kind of dynamic. Judges are more sophisticated, I think, consumers of evidence than juries in general. And it is a question to which there's no certain answer. Inevitably, the judge is sitting there using his or her biases, values, experiences, life experience as a parent, as a child. And judges often recognize listening to someone else who has a lot more experience in working with families and who has met with this particular family, worked with, interviewed them, will often help him or her come to the right conclusion. That doesn't mean that the recommendations are binding on the court. To the contrary. I think that the reality is, as Lorena said, in most cases in which you do an evaluation and you make recommendations, the party will settle. You, in effect, are a kind of decision maker. I wouldn't want to say you're a kind of a judge, but you do have that kind of role for this family. You've helped them come to a decision based on your recommendations. They are involved. They read your report. If they find it persuasive, they will settle. On the other hand, if they disagree with you and they hire a lawyer like Tim Tippins, you will be on the witness stand and you'll be cross-examined. Why did you come up with those recommendations? Can you justify them? To what extent do they relate to literature? To what extent do they relate to your observations? Why are you coming up with that recommendations? Is it supported by to what extent is it consistent with what has been done in terms of scientific research?
It dawned on me that there was a presentation yesterday given in one of the workshops on gatekeeping functions. And kind of applying that term here, we're talking about the judge as the gatekeeper and whether or not it's going to be an inclusive gatekeeper or an exclusive gatekeeper and what rules they're going to use. And one of the things I hear differing in the two positions, I hear somewhat in Nick and Lorraine's position of this more inclusive gatekeeper who in some ways the mental health professional becomes an assistant gatekeeper. Whereas I hear in the Tim and what's-his-name position, that it needs a very specific rule and that the judge can't be trusted to decide that this is going to be a collaborator with him. I'd like, and I'll start with your side, I'd like you to respond to that a little bit.
First of all, I think we need to distinguish between whether we're talking about settlement considerations or are we talking about adjudication by the court. The concerns that Lorraine raises are all perfectly legitimate, understandable, and practical, but our model doesn't touch them. Our model kicks in when the courtroom door opens and a trial begins where rights are going to be affected by force of law. So if we're going to use, and I believe there are many levels at which mental health professionals can be involved in this process other than being in the courtroom testifying, if we're going to use that expertise and subjective judgment and so forth as an assist, then let's have a dual track or a parallel process to do that so it does not later contaminate fact-finding and adjudication that truncates liberties by force of law. I have yet to hear defined by the other side what evidentiary reliability is going to protect the child. We keep saying that these cases are different. Well, sure, they're different, but why does that translate into dropping the floodgates and allowing children's futures to be decided not by the parents who settle? They can settle on any basis they want. That's a voluntary process. But through the involuntary process of a formal adjudication, why is a child entitled to have a lesser evidentiary safeguard than anyone else? And if you don't have an evidentiary safeguard, we're going to allow these opinions because we're going to allow these opinions, then why would that even be confined to social workers, psychologists, and psychiatrists? Why would that, what then keeps the philosopher, the metaphysician, or even the astrologer out of court? It's only the evidentiary safeguard, the standard of evidentiary reliability, or as it would be spoken of in mental health quarters, validity, that sets up the expert witness as one who can give inferences as opposed to fact. And until they can answer that question, these sub-questions become extraneous. That child is entitled to the same evidentiary protection as any other person affected by a court order.
One of the things I would want to remind you, Arnie, about this question of kind of collaborating and having more of an open, collaborative relationship with the court is that if you look at our original piece, one of the emphases in the piece was on the wealth of literature and expertise we have to bring to the court to collaborate as long as it's valid and reliable information. It's interesting to me how this discussion goes, because we get into comments about these are so helpful, these reports. Well, if you define helpfulness as clearing the docket of cases, they're tremendously helpful. But if you define helpfulness as what it does for the child, it's an entirely different question, and we just don't know. We just don't know whether from that perspective they are in fact helpful, but they do clear cases, they do clear dockets. Remember that we have a 30-year, at least, history of a dense research literature on clinical judgment error. That is one reason why these reports should be looked at with great scrutiny. If you go outside the door and you talk with, or right in here, talk with attorneys and ask them about their communities, you're going to hear, well, psychologist Smith on average thinks joint custody is best. Psychologist Jones says no, primary placement is best. Psychologist Smith tends to think that children should be placed with their primary psychological parent. Psychologist Jones, on average, wants to ensure maximum access to two parents. Psychologist Smith thinks that children under 3 shouldn't have overnights. Psychologist Jones says, oh, certainly they can have overnights. Children should never be placed with a parent who's engaged in domestic violence. Most of us would agree with that. However, what if the other parent is a seriously deteriorated alcoholic? Reasonable people can disagree. If a child says it's true, it's true. No, there's lots of literature that some psychologists would argue that's not necessarily the case. Children under 12 or over 12 are competent to make a decision about where they should live. Well, yeah, but we don't let them buy 6 packs of beer. It's best to give a custodial advantage to the parent who works fewer hours. No, psychologist Smith says that's not fair to the parent who earns the most money. Okay, there's a lot of variation in our field, and we need these kinds of evidentiary meshes to be cautious about what gets admitted.
Nick, do you want to respond to this stuff? The original question was about gatekeeping, by the way.
And I agree that judges are clearly gatekeepers. The question, and in fact, they're gatekeepers at least twice or 3 times. Their initial gatekeeper when they make the order for an evaluation, and that's one key point, decision point in the process. And generally speaking, at that point, they're going to be asking for a recommendation, I think quite wisely, knowing that that's a case that already, typically, and it depends on the justice system and the lawyers, there's been attempts to settle already. They have, by definition, not settled without an evaluation. They tried some mediation, negotiation, and the lawyers say, looks like we're going to trial. The judge says, okay, let's have an evaluation, and I want the evaluator to come up with some recommendations. I'm not bound by them, or whoever hears the trial is not bound by them, but let's get those recommendations. And we know that a very significant number of cases will settle based on that evaluation between the time of the evaluation and the trial. That's the way the real world works. You have that, and if you didn't have the recommendations, I think you'd have less likelihood of having a settlement. And a settlement is not only good for judges, and in fact, who is a settlement bad for? I mean, I don't want to make an ad personam kind of comment, but obviously, if a certain view, it's not particularly good for trial lawyers who expect to who make their money by trying cases. Having said that, the vast majority of family law practitioners are highly ethical, in my experience, certainly in my country, and they do try to settle cases often based on that evaluation. They say, this is a valuable tool to help us settle. It may settle a case. If it doesn't settle a case and the case goes to trial, you then have the judge listening to that evaluation, not bound by it, but it's often better for the child's outcome and for an ultimate decision to have all of those opinions there. But when you ask about, come back to settlements, settlements are valuable not only for judges, they're particularly valuable for children. And we do have some research about the psychological costs for children when their parents go through the trial process. We'd certainly like to have a lot more about that, but generally speaking, the welfare of the child is going to be helped by a settlement. Lorraine?
A couple of points. Tim, now, having met you, I better understand why in your state morality is an issue. Just a point. It's not relevant to anything. I just needed to make it.
Blah, blah, blah.
Blah, 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 blah. You deserve that. First, the gatekeeping issue. It's my experience that even though the court makes an order, and I read the judgments of our cases that go to court, that the recommendations are not automatically accepted at all. In fact, are frequently completely separated. So I think in reality what you're talking about happens. I also do not know how you're going to predict which cases go to court, and so you don't give recommendations to, and which cases are not going to go to court. So do you take the recommendations out if it goes to court? None of that seems very practical to me. In terms of helpfulness to the child, I do believe that one of the pieces of research that Dr. Birnbaum did, if I'm correct, in some outcome of our work that we do, is that one of the best things that comes out of the work that we do is that the parents get refocused on the child, away from their conflict, back to the child. And I believe universally we do that good, and in that way are helpful to the child.
Now, if you want to take the position that your clinical experience by itself allows you to predict the best parent in a given case, I would ask you, how many evaluations have you done? And how many of your recommendations have been followed? And how many of those children who have been placed in accordance of your recommendations had positive outcomes as opposed to negative? And most evaluators I know don't have that feedback, and therefore don't know whether they're getting better or worse, getting it right, getting it wrong. It's not the evaluator's fault that that feedback doesn't exist, but the absence of that feedback limits the degree to which clinical experience can provide the answer to this particular question.
And could I just say, in response to all those questions, which I think are very good ones from a research point of view, we don't know what the outcome is from when judges decide what's in the best interest of children either. So it's really, the question is not, to me, what could one do in an ideal world, but in the real world, it is often very helpful to have somebody else who has a lot of experience with children and families, who knows the research, come in and give an opinion as well as hearing from the judge.
But
Okay.
then the answer,
Stop, please. Done. Question.
Well, that was actually the gist of my question is, what alternative do you have? It seems like we're going back to the 1960s if you're going to exclude recommendations. And you talk about parents' rights, but those rights are going to be impaired by entering into the divorce process. So seems to me that what you're saying is you're turning this over to a judge and excluding valuable information which is incorporated into the recommendation. So I guess what alternative do you have if you're basing exclusively on empirical data?
Yep. It's not valuable if it's not valid. Remember that one of the things that Tim and I kind of joke before we do seminars, let's count the number of times that we talk about the importance of these reports and the valuable information we can give that can help the person who is endowed with the job of making these decisions, and then let's count how many people will come up to us after and say, so you're saying throw these things out? And it happens to us all the time. I got a call from an attorney last week who got one of my reports. I did a risk analysis. The risks associated, psychological risks associated with primary placement with mom, the risks associated with primary placement with dad, and the risks associated with shared or joint custody. He called me up after the court date, and he said, I want to thank you for that report because it settled the case. And the parties walked away seeing what they had been doing that was hurting their child. There are ways to do these reports that can be tremendously helpful, even though we are proposing tearing off that last page that says, therefore, place the kids with their mom every other weekend and a Wednesday night.
And if I can add to that response, implicit in your question is a very good question, and that is, what makes us think judges are more capable of coming to these answers than our mental health professionals? And you know something? That's a very good issue that we really need to have debated. But because that would be intellectually honest. We would have to change the Constitution. We would have to change an awful lot of statutes, but it would be a public policy debate in the legislative forum where mental health proponents can come in with whatever evidence may be there to show that they have superior insight, and we can have that debate. That's a lot more intellectually honest than what goes on presently, which everyone pretending that the expert witness knows more than he or she actually knows. At least it's honest.
All right, thank you. I'm going to take one more question, then I'm going to ask some questions.
We have some data on what judges do as gatekeepers. We have data that says judges love the role of gatekeeper. Who wouldn't? The problem is the research also says that they don't understand the Daubert criteria. They don't understand falsifiability. They don't understand error rates. In fact, less than 5% seem to understand those concepts. So it comes down to this, according to the research: the qualifications of the expert, the relevance, and the general acceptability of the testimony. How is that helpful to put in the hands of a judge who's bestowed by society with this ability, but not the knowledge? Why are we giving to a judge the ability to make decisions when some of these people come from business law? Some of them come from writing wills and testament. They have no clue about social science research, and they're asked to be a uber decider of an entire realm of science? How do we do that?
The answer, you can come to one of, they're very valid points, Jay, and you can come to one of two answers. You can either say, let's disembowel them of that authority, which is a debate that could be had, or the answer, you've got to educate them as to those things. That's why you said they love to be gatekeepers. My experience with individual judges is different than that. My experience with a lot of judges, and certainly none in this room, but with a lot of judges is their mantra every morning when they get up facing a trial is let this cup pass, all right? This is hard work. The answer is to do in the state courts and in the family courts what the federal judiciary did. They have an entire manual written on science and statistical analysis. They run seminars up the yin-yang with respect to these issues that they must know. And they can't, you're absolutely right, they can't apply Daubert without that kind of education. They have to have it. And unless it's provided, they're going to do a lousy job. Why do you think they liked Fry? Because it was easy. They didn't have to figure out anything other than counting noses, and at least they could count. All right? Daubert requires them to directly assess and understand those very concepts that you mentioned that are implicit in Daubert, and they can either get educated and get with it, or we can keep doing business as usual and receiving the junk science in, not just in this field, but across the litigative landscape.
Okay, thank you. This side.
I think that judges and society is aware that in criminal cases and in tort cases and commercial cases, there does have to be that standard of reliability. And so in the United States, as in Canada, judges are slowly being educated about scientific reliability and validity issues. But those seminars are in the context of tort, criminal, and other kinds of litigations. When I've been to a judicial education program, I've never been one in the United States, I've been to many in Canada, where they're focusing on the best interests of children, there's a very different approach. And the approach doesn't just come from judges. It largely, or in significant measure, comes from the legislatures. Now, this depends on the jurisdiction in which you are practicing. But in most jurisdictions, or many jurisdictions, there is a set of rules from the legislature or the Rules Committee that says, here are the circumstances in which an evaluator can be appointed by the court. In other words, it's not just a decision of the judges. The legislature said, we want to have these evaluations. In some cases, they specifically come out and say that there should be, in some jurisdictions, that there should be a recommendation, or there may be a recommendation. Sometimes they're silent. But to the extent that judges have interpreted these provisions consistent with evaluators giving a recommendation, I believe that they're actually carrying out the will of the legislature. If the legislatures had the view that has been put forward by Jeff and Tim, they would have said, we don't think that evaluators should do this. In general, in our society, I think if you ask most politicians, and to the extent they've addressed it, they say, of course we want your opinions if you have the appropriate training and qualifications. They will be valuable to the courts to help resolve cases, either through settlement or through litigation. It doesn't mean that they're always going to be accepted, but they could be a valuable part of that process and will help advance the interests of children. So to me, what's actually been going on is a reflection of democracy and the wisdom of our society. And here we have some critics, and they're, I believe, a minority, but an important voice, saying, really advocating for change. And if they could persuade a legislature to say, you're right, we should not hear this, let's train the judges, let's have a different system, that will be fine. But in fact, I think somebody said, we're talking about going back 30 years, and I think that's right, or 40 years. We're going to go back to a time when we're going to have much less evidence, not no evidence, but less evidence from mental health professionals who go down this route. A lot more litigation, fewer cases being settled. I think that would be contrary to the social interests of both the financial interests of society in running the justice system and the interests of children. That's why I would argue we shouldn't go down that road. But there's an argument that's where we should go. I just don't think it's been persuasive with the lawmakers at this point.
Thanks, Nick. Interestingly, Tim, you said before that if we're going to let psychologists in, we should let astrologers in and palm readers or whatever, kind of comparing some of the science or lack thereof. And I think, Jeff, you kind of said we're a profession who allowed people to hit each other with pillows or batakas or whatever it is you were referring to and found out something afterwards. Well, have you ever cross-examined a judge on whether he went to an astrologer that morning and figured out what he should do? Meaning that, at least in this system, the psychologist is sitting on the stand, and you're hearing what information he's getting from, the judge is getting from his assistant. Whereas you don't have that option if he's not there. Is there not any benefit to that, given what we've talked about with the social science research that he can be getting educated about?
First of all, I am not comparing psychologists to astrologers. That's not what I said. What I said was, Arnie, is that in the absence of a standard of admissibility, in the absence of a court's gatekeeping function to look at evidentiary reliability and validity, that is the only thing that allows you onto the witness stand and at the same time keeps the astrologer or the metaphysician off. Once you do away, as Nick proposes in his article, with applying the evidentiary standard of experts to psychologists or social workers or psychiatrists, we have simply dropped the floodgates, and we will now not be able to keep out other species of testimony that we would all probably agree to be highly speculative. We, again, have never said, as Jeff has reiterated a couple of times, that there is no value to be had from mental health professionals, either in the settlement context, which can be tremendous, or even in the testimonial context. I know many of you have not yet read the article, but if you read our article, and I would recommend you not simply read ours in that April 05 edition, but Phil Stahl's and Martindale and Gould and Kelly and Johnston, the whole gamut of opinion is in there. If you read our article carefully, we're saying at level 1, the psychologists can bring tremendous value, and at level 2 on psychological constructs, and even to a degree on level 3 with respect to custody-relevant constructs. We're saying, because of your expertise, we want that information, it's valuable, but we want you to stop where the research ends. Okay. That's what we're saying, so that there's validity to what you say as opposed to your own inner lights guiding the opinion.
So basically, you only want the attorneys misleading the judge. We don't want the psychologist doing it.
Yeah. Just as incompetent or shyster attorneys do a disservice to one and all, so do incompetent evaluators. I agree.
Thank you.
In what I was saying, I'm not saying that everybody should be able to say anything they want in the article, and in here I think I made quite clear that evaluators have to be qualified, and there's certainly a lot more that one can do in terms of raising professional standards.
Mark from Minnesota. I'm a family law attorney. I practiced family law for 17 years, and I heard earlier that there's a market out there for custody evaluations that have recommendations. About 80% of the attorneys want them, 80% of the judges want them. So the market is going to direct that. And if these good mental health professionals out here suddenly decide that they need to go on a little moratorium because it's not valid science, the market is going to go to the less professional evaluators, and they're out there. I've seen them. They're awful, and they guarantee trials, awful trials. You want the best people to do the best evaluations, but it's going to come down to a crapshoot. And if we don't do them, there's going to be a lot more crap.
Thank you, Mark. I don't know if there's a real quick response.
We're saying do them, all right? We're saying do them. And the issue you raise is a very practical issue, and in fact, John Gould and David Martindale, in their responsive piece, speak to that issue. And what they said, in effect, is you go first, legal profession, after you. And they're absolutely right. And they say, because if all of a sudden the ethical and the scientifically minded practitioners say we're not going to do that, then it's going to leave those who are less scrupulous to do it. And it's a valid market argument, and I agree with them. Legal profession is ultimately responsible and has to go first and say, no, nobody's going to be giving us stuff that's invalid. That being said, there's also a valid ethical issue for mental health professionals to consider, because that argument lends itself to this. Because judges and lawyers want these opinions, even though they overreach our data, we're going to give them. And somehow that seems to be what's going on.
Okay.
But if your patient walked in, and said, I want Prozac, do you just give it to them because they want it? I don't think you do.
Stop. Thank you. Next.
Hi, I'm Linda Gunsberg from New York. Just want to say that some of the history of the Tippins-Wittman controversy came after there was some case law, some cases where there was the question of how much weight the judge gave to the forensic report. And so there was a whole question in the legal community as to whether or not judges were willingly giving over their power to mental health professionals. So
what is the question?
My question is this. Are you aware of what's really happening as a result of this controversy? And
Yeah, in New York, we're very much aware of it. A number of judges still allow recommendations, and more judges are putting in their appointment orders, do not give us recommendations. So there has been a fundamental paradigm shift. Nick's article says, in effect, he concedes that the custody recommendations and other best interest opinions cannot meet the Daubert standard, and they can't. at least not on the basis of the present state of the research. His answer is, therefore, we drop the standard. We lower the bar to get the result of allowing opinions in rather than saying what needs to be done to raise the bar of practice to provide more and more valuable information to the court without running afoul of the ethical and evidentiary precept that we need to keep unreliable, unanchored opinions out. We say you have a ton of value to bring to the table without you having to overreach the database of information that your professions provide. Once we say, as Nick would suggest, that there's no standard that applies here, that we bring in everything for weight and the judge can sort out whether he or she believes it or not, and it's all a question of weight rather than admissibility, then we throw those courtroom doors open to virtually anybody. And if you go to the Otto Emery and O'Donoghue article in the 2005 publication, you'll see where they say, what is to keep out these other species of expertise in these cases, if not an evidentiary standard? And it's no answer to say, well, these are court-appointed experts. That's what he suggests in his article. They're court-appointed, therefore they shouldn't have to comply with the evidentiary standard. You know, all you do with a court appointment is, first of all, it's convenient and it serves an interest of expense. But the only thing you accomplish beyond that is you remove retention bias. All of the other mechanisms, well-researched and documented over the years by the behavioral science research, are still present. All of the cognitive distortion mechanisms and bias, confirmatory bias, anchoring, primacy, recency, individual heuristics, untested pet theories that are brought to bear. And you could go on and list a score or more of cognitive distortion forces that operate whether you're court-appointed or not. Nick's article suggests almost that court appointment transforms you not into an expert witness, because he says you're not experts, but into an oracle. And then you can get on there and say anything you want because we've accepted that level of expertise. That takes us back literally to the pre-Fry era of ipsy dixit, it's because I said so, 30 days, next case. I don't think that's acceptable to courts. It shouldn't be, and our children certainly deserve a higher degree of evidentiary integrity than that. And if we're going to allow it without application of an evidentiary standard, why can't I call in Carolyn Miss to give her testimonies to what she thinks would be best for the future? Why can't I call in a theologian to give opinions about the moral character of the folks? It would throw the floodgates open. If you accept his premise and his subtitle that you're not experts, when we open up those floodgates and let all the rest of it in, we'll find ourselves awash in a sea of junk science and speculative opinion, and you're going to find yourself washed out the courtroom door along with the rest.
Thank you, Tim.
The best shot is to be empirical.
Thank
you.
Okay, Nick.
Now I know I want to write a reply at the end. In the article, which is in your materials, I do say that experts may not, evaluators may not be experts. The word experts is in quotation marks. And I go on to explain that you may not be experts on the Daubert standard, but you do have expertise that must be informed by research in the area. And I go on to say, in the materials, I italicize it, you should be relatively easy to find. I say that evaluators should only be giving evidence based on generally accepted procedures and their training and expertise and education within the field, and discuss what that would be. In a very broad sense, it might be a Fry kind of standard, although I would probably avoid that kind of terminology. So I think there are some very important standards that must be maintained in your profession. Let me say that this debate has had several different audiences. One is the people in this room, and not only in this room, but other evaluators who are reading the debate going forward. And I would say that one very important cautionary note is that whatever your view about this debate, to a large extent, you should be following the laws and instructions in your particular court. And that is to say, if the judge is saying he or she doesn't want recommendations, no recommendations. If they're asking for it, generally speaking, I think it is socially useful and appropriate to do that. I also, though, agree that there are some cases in which it is appropriate to say, even though they're asking for recommendations, I simply can't make them in this case for any one of a number of reasons. Certainly the argument that Jeff and Tim have put forward is extremely important, and I would very much commend to you their article to be aware of it, to be thinking about it, at very least to be taking away the idea that you have to be familiar with the research in the area, continue to educate yourselves. You must be aware of, is what you're doing generally accepted within your field? That's the kind of standard that I would put into place. Some people are not following generally accepted procedures, and they are often, but not always, being called to it in court. I would say that there's a whole other audience that we've been addressing at different points, and those are the lawmakers, who in some cases would be judges, some cases might even be lawyers, largely they're legislators, in some cases they may be appellate court judges or law review article authors. And I think that for those people who are making the laws, they have to be listening to this debate going forward, and if they're persuaded by Jeff and Tim's view, not only on its and it was very articulately stated here, but also in considering its implications for children and families, then they have to put the laws into place to make that clear. But in our present circumstances, I would submit that most judges are correctly asking for recommendations in most cases.
Thanks, Nick. I was going to poke him on the shoulder. First of all, I want to thank you both. You've made a tremendous impact on my practice and in the direction that I give to the practice in my province. Your level 1 through 4 is an excellent description of the process of the evolution of an evaluation, and your emphasis on observations on behavioral evidence was really profound and raised the quality of the work that we do in my province, and I thank you for that. It's just too bad you had to be wrong. And as I listen to you, Jeff, I think that you're almost making the argument as a way of quality control from the junk. I think there's a lot of other ways to get quality control without going to the step that you're recommending. And my last statement would be I would still never want to replace the wisdom of the people in this room who have been doing this work for 15 and 20 and 30 years, the collection of clinical experience, other families they've worked with, and the thought they give to those recommendations as a roadmap for those families. And I would never want to lose that. Thank you.
Okay. We started this debate this debate series with a look at the model standards. And you will note in our model standards that they do not exclude the possibility of making recommendations in your custody evaluations. They do very much say that you have a proactive obligation to note the limitations of anything you do and say, and to state those explicitly so that the court understands the limitations of the inferences and conclusions you were reaching. So I would just say to you to keep that in mind. I want to thank you all for what I found to be really interesting and a good time amongst it. I think you really have helped us raise our level of thinking and insight. So thanks, everybody. Have safe trips home.